what it is you want to say or not, because you're interrupting me.
Okay. Go ahead.
Because something you say could be used against you.
Mm-hmm.
So that is why I indicated if your attorney suggests that you speak.
I'm just saying the Michigan tenure provision needs to hear about this.
Okay, now I'm holding you in contempt. I've already indicated that you are not to interrupt this court, yet you have continued to do so. I've given you one chance. I've given you one chance right now. The court is going to indicate, pursuant to MCL 600.1701, that you are engaging in disorderly, contemptuous, insolent behavior during the immediate view of this court and in the court's presence, directly tending to interrupt its proceedings and impair the respect due to its authority. Further, that under MCL 600.1701B, that this court finds you are in contempt during any breach of the peace, noise, or disturbance directly tending to interrupt this court's proceedings. The court will also indicate that this has occurred in the presence of the court. Therefore, the court may punish you summarily by fine or imprisonment or both. Stop interrupting, sir. Therefore, the court's going to indicate "15 days jail for contempt." The court's going to also indicate that while, sir, you were quiet and not interrupting this court's order, nor the proceedings, towards the end of the proceedings, then you began to interrupt this court. Despite this court's order not to.
Not to speak my mind?
Not to interrupt this court. Therefore, as is evidenced still by your continued interruption of these proceedings, the only corrective action necessary to restore order and maintain the dignity and authority of the court is to hold you in criminal contempt and sentence you to 15 days jail.
Okay. But hey, you filed a false police report, you let it get in your courtroom. So did the prosecutor and the team.
Sir,
we'll hear about it, and it's already, you got a grievance on you already right
sir,
now.
You may file anything that
June
you
the 1st. Hey, listen,
you
this
may
domestic violence.
stop interrupting.
You're gonna
stop interrupting. Okay, well, at least you're helping the court make a record for yourself, for the court as well, as to why this court found you in criminal contempt. We'll see you next week on the 17th.
Baby.
You're not to address.
Okay. I'm addressing the bar though.
Sir, the court's adding another 10 days time for you addressing the victim in this matter. The full 25 days. Off the record.
In today's video, we have two follow-up cases. The first follow-up is on the case that you just saw in the beginning of this video, where the defendant was held in contempt for causing a disturbance in the court when the proceedings weren't going his way. The second follow-up is from Judge Kennedy's court, where we have an attorney who gets upset and yells at the judge over the court's incompetence to file important documents sent to the court. So without further ado, let's get into the video.
All right, we are going to go on the record in the matter of the state of Michigan versus Shadeen Howard Randolph, 23302. And appearance for the people, please.
And good afternoon, Good afternoon, I'm checking here my client.
Thank you. Your name, sir?
Shadeen Howard Randolph.
All right, thank you. And today's the date scheduled for the adjourned bond violation hearing. And counsel?
Your Honor, today's time dates at the bond violation hearing are claiming witness, however, has not appeared. I'm going to ask the court to issue a show cause for her. She wasn't keen to be here. She did request a subpoena to be served to her electronically. I sent our victim advocate sent to her electronically by Thursday or Friday of last week. I did receive a copy of the email she sent. She also CC'd the victim's attorney at that time as well. Furthermore, this court also ordered her orally to reappear at today's time and date. and that she would need to appear for the show cause hearing previously for the bond violation hearing. So I would just ask for the issue of show cause for her appearance. Based on that, Your Honor, and also the fact that we received some communication indicating that the defendant contacted the complaint from the jail last Thursday on the 11th. I would ask the court to adjourn the bond violation for 1 week to next Wednesday. I believe that would allow us additional time to locate the complainant as well as to get additional records for that violation period during the jail, the call from the jail on the 11th by the professor.
All right, thank you, Mr. Chairman.
Your Honor, I'd object to the adjournment at this time, Your Honor. At the last court proceeding, we were here for approximately 2.5 hours. Complaining witness failed to appear and that furthermore appeared on video. She indicated that she did not want to proceed. My client was put into custody. I understand that there was allegations of contempt. However, we are here now again, and the complaining witness did not appear. I know that this allegation stemmed out of a matter that may have happened in Macomb County in April, but to this date, I don't see anything verifying a charge against him. And as to calls made from the Wayne County Jail to complain it, all I've seen is a potential email indicating that a call was being made. I see nothing beyond allegations. So I'd ask that the adjournment be denied, and at this time I'd ask for the amendment to be dismissed and set for remaining of the bench trial.
All right, so the court will note that yes, everybody was here for quite a while. On May 10th, there was concern as to where Ms. Duff was because she wasn't responding to any messages, emails, or phone calls. The court will note that Ms. Duff did Zoom in. Counsel objected to Ms. Duff testifying via Zoom. And so the court set this matter for an in-person hearing today. The court will also note that there was an email sent to the 27th District Court email indicating that there's an allegation that Mr. Howard Randolph contacted Ms. Duff from the Wayne County Jail phone the day after he was here in court. With that new information and the fact that Mr. Howard Randolph is currently in custody for contempt proceedings, the court is going to grant the people's motion, adjourn this. We're going to adjourn this 1 week. We're going to also issue a show, the court's going to also issue a show cause for Ms. Duff, and we're going to schedule this for May 24th at 9 a.m. Mr. Howard Randolph, I'm going to remind you that you are not to have any contact with Ms. Duff. That's phone contact, text message, email, social media, third party, package delivery service, whether it's FedEx, Amazon, any UPS, whatever it may be, United States Postal Service, nothing, no letters, nothing. Do you understand that, sir?
Yes.
In fact, didn't I say last time that there was a violation, I was putting him in solitary confinement?
I don't have a recollection.
Okay, that may have been Mr. May have been a different individual. I don't have a note as to that effect. Anything else for the people?
No, thank you, Your Honor.
Anything else for the defense?
No, Your Honor.
All right, the court's going to indicate bonding conditions are continued, and we'll see everybody back May 24th at 9 a.m.
Your Honor, just on a housekeeping issue, I know that this is something that I want to bring to the attention of potentially my client asked to be brought up. He indicated that on the second 10 days of contempt that he was not talking to the complainant, but rather his son. Judge Fred, potentially we can look at the transcript and see what, or even potentially recording to see what name was called out. I know that we're—
Baby was the name. I love you, baby. That's what it was.
At this point, I'd ask just that in the next week, there's consideration as to that, depending on the nature if there's no contact, because I understand he has 15 days, which means that he'll be in custody still on Wednesday, even if the 10 days were to be taken back today, correct, Judge?
Correct.
So I'd ask that I could revisit the second contempt charge at the next court proceeding, which would still be within the original 15 days, keeping him in custody, but potentially having that set aside. Is that something I can readdress with the court at that time?
Sure, you can readdress it on that date. The court does recall very vividly that as Mr. Howard Randolph was being transported away from the podium, that he looked at the screen and yelled, "I love you, baby." And that the only individual that was there at the time was Ms. Duff.
I do believe there was a baby crying.
Correct. The only one that was on the screen was Ms. Duff. So,
and I'd ask that we could revisit that potentially at the next court proceeding.
You may, yes.
Thank you for the consideration.
All right, thank you. We'll be off the record.
Meanwhile, in Judge Kennedy's court, this attorney is very upset over a lost proof of service. We covered this judge before when another attorney, Mr. Bejani, was upset with the defendant's attorney and Judge Kennedy. I'll link those videos below. After watching several dockets, I did notice a pattern where turned-in documents were not getting filed, which have resulted in a lot of dismissed cases. Multiple attorneys have said they turned in documents just to have them get lost in the court's possession, but this attorney seems to have had enough and makes his expressions well known to the judge.
I'm not going to give you a submit by date, Attorney Callahan, because you'll be in person, and hopefully if you haven't filed it by then, you can hand it to me over the bench. So, but if I don't have the deed by that date, the matter will be dismissed. This matter is adjourned to June 6th at 10:35 a.m.
Thank you.
You're welcome. Have a good day. Now calling case number 233422225, Grant and Main versus all occupants of 19 the city of Detroit. This matter is scheduled for pretrial on a complaint to recover possession of property. May I have plaintiff's counsel place your appearance on the record?
Kevin Callahan for plaintiff, P78273.
Thank you, Attorney Callahan. Is there any occupant of 19 in the city of Detroit? Okay, we have, are you here, ma'am, on, do you reside at 19? Okay, Attorney Callahan, I have a proof of service in my file, but it states that notice was posted at 11. Let's see. This is obviously the wrong case number. Do you have a proof of service over there, Madam Clerk? Don't have one for this one. All right, let me check.
I'm looking at a proof of service for Beeland Street. That service was effectuated by tacking on the 20th of February, it looks like. Or 26th of February.
It's not submitted to the court, Attorney Callahan. I'm looking at the
court, Judge.
Are you looking at the register of actions? If so, can you direct me to?
All I know is that my process server dropped it off with the second floor, so it was turned into the court. I can't be responsible for placing it into the court file. That's all I know, Judge.
Well, I have proof of service for your other ones. Well, let me see. Not for one. I'm not going to grant the judgment today. I can't do it without the proof of service. I'm not going to dismiss the matter, which I should, because there's no proof that the defendant was served. And if the register of actions had reflected that a proof of service was filed, you know, there wouldn't be a doubt. But the register of actions doesn't reflect it. There's no paper in this file that says that the defendant was served. So I'm not granting the motion. I'm not granting your motion for default judgment. I am clogging my docket up with these cases.
Judge, I have a proof of service.
But I don't have it, Attorney Callahan.
That's not my fault, Judge. This is okay.
This matter is dismissed without prejudice.
Fantastic. I will appeal your decision. Can you sign the dismissal forthwith?
As soon as you submit it.
Well, the court doesn't even do that. So, okay. Thank you, Judge.
Will you hand me my screen box?